Whiteley, please. So I'll start us off with the introductions. My name is Austin Whiteley. I am the now former president of the Federalist Society.
Former? You stepped down? Abdicated?
We had our elections last week.
He was impeached?
I was impeached.
You had the corrupt intent.
Here's John, our new president. So, didn't know he'd be here. So John is now the acting president of the Federalist Society. This is my last event as president. And I will be introducing our first guest. Professor Josh Blackman is an associate professor of law at the South Texas College of Law in Houston, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman is the author of the critically acclaimed Unprecedented, The Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty, and Executive Power. Professor Blackman was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Professor Blackman has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He is an adjunct scholar at the Cato Institute. He is the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league, and he blogs at joshblackman.com. Professor Blackman is the author of over 4 law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications. Please help me welcome Professor Blackman.
Hi everyone, my name is AJ Foreman and I am the former president of the American Constitution Society. I resigned before I was impeached. And I have the great pleasure of introducing you all to Professor Rave, who many of you know, but some of you may not. Professor Rave is the University of Houston Law Center professor, and he's been here since 2013, where he teaches in the areas of civil procedure, constitutional law, election law, and complex litigation. As a student who has taken 2 of his classes, somewhat challenging, but ultimately rewarding and very fun, but you don't have to take my word for it, because in 2018, he received the university-wide Teaching Excellence Award. Professor Rave is a graduate of the New York University School of Law. He served as a clerk for the Honorable Leonard B. Sand in the Southern District of New York, and also for the Honorable Robert A. Katzman on the U.S. Court of Appeals for the Second Circuit. So please join me in welcoming both Professors Rave and Blackman.
Thank you.
And without further ado, I know some of you are still grabbing food, and that's fine, but we will get started just for time purposes. Thank you.
Okay, thank you so much. It's a pleasure to be here at UH. I teach at South Texas, across the highway. I see some of my former students are here. They tend to transfer this way, not that way, but that's how things tend to go. Our topic today is the Foreign Emoluments Clause. And this is a portion of the Constitution that most people gave zero thought before the election of President Trump. But almost immediately after the inauguration, a series of lawsuits were filed alleging that President Trump is violating the Constitution. Specifically, that his business interests, which cater to foreign governments, are resulting in him receiving unlawful emoluments from foreign governments. The Foreign Emoluments Clause reads, and I'll read it in its entirety, "No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them," and then refers to the United States, "shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever, from any king, prince, or foreign state." So there are 2 important questions here. The first important question is, what the hell is an emolument? It's a word which you probably never used before, which you probably never even read in any book. It's a fairly old word, and I'll get to that meaning later. But the first question that I want to spend most of my time on, which I think is a much more difficult question, is who holds an office of profit or trust under the United States? Now, the clause doesn't say the president or members of Congress. It uses this phrase, those who hold office of profit or trust under the United States. You may not really think much about this language. You think, of course it means the president. Why wouldn't it, right? I've been working now in this case for nearly 2 years, and I've been working with a law professor in Ireland named Seth Barrett Tillman. And he wrote about this clause a decade ago before anyone even cared about it. And his argument is that this phrase, office of profit or trust under the United States, had a meaning, which we don't think of much anymore. But the idea of having an office under the United States refers to not people who are elected, but people who are appointed, such as a Secretary of State or an ambassador. So far, only one court has actually opined on the meaning of this clause, and the judge very vigorously rejected our argument in several pages, but that doesn't matter. That just gives more attention to us. So I'll walk through that. The fact that he even had to respond to us, I take as a moral victory, because in the early days of this litigation, people just wanted to dismiss us and just get rid of us. So I want to introduce this beautiful graphic, which Seth and I made 2 years ago. We call it our taxonomy. Right? You can see it okay, Teddy?
Oh, yeah.
Okay, good. Very good. I'm sorry I have to crane your neck a bit. It's beautiful, right? I remember I made this when during the Hurricane Harvey evacuation. I went to Dallas for a couple days, and I was stuck in a hotel, so I made this graph. So this, it's good memories or bad memories. There are different clauses of the Constitution that refer to different types of officers. Okay? There are officers of the United States. That's the gray circle over here. There are offices under the United States. That's the orange circle. And then there's office under the authority of the United States, which is that pink or salmon. I don't even know what color this is. Some sort of pink color, right? And then you have this other language, public trust. All right? I want to walk you through these one step at a time. And I don't need to convince you that Donald Trump is acting lawfully or legally. I actually don't care about that. All I want to convince you is that there's some pattern to how the Constitution uses this language. That's not arbitrary. Our opponents in this litigation have said it doesn't matter. When the Constitution says office, it refers to everyone. It doesn't really matter who it refers to. I want to show you that position itself is wrong. So let's start with the phrase officers of the United States. This is the gray circle. All right. In 4 clauses, the Constitution uses the phrase officers of the United States. First, the Appointments Clause. Oh, my little laser doesn't work on this monitor, so I'll point. The Appointments Clause. The Impeachment Clause, which also narrowly avoided impeachment. I'm grateful for that. The Oath Clause and the Commission Clause. In each of these cases, the language is officers of the United States. This is actually the easiest one. Justice Story wrote about this over 200 years ago, and he said these positions are derived from their appointment, not from the people, right? They're appointed, they're not elected. And the Supreme Court has basically said this in several junctures, right? The phrase officers of the United States refers to those who are appointed. It makes a lot of sense in the Appointments Clause, right? You can't appoint the president, right? You can't appoint a senator or a congressman, but you appoint an officer of the United States. The same for impeachment. Just about everyone agrees that you can impeach a member of Congress. There was actually debate on this early on, but I think it's been settled enough that a member of Congress cannot be impeached, right? Only officers of the United States can be impeached. The Oath Clause, for example, there's specific types of oath for senators, representatives, members of the state legislatures, and another oath clause, right, for the executive and judicial officers, those who are appointed. The Commission Clause, right? Remember Marbury versus Madison. Did he get his commission in time, right? In order to be an executive branch appointee or judicial appointee, you need your damn commission. Only appointed officers of the United States get commissions. There's no evidence the president ever got a commission or a member of Congress. Only appointed positions. Right, so far, this should seem very obvious, right? I think on this argument, we're on pretty solid ground. That the phrase officers of the United States can only refer to appointed positions. And the Supreme Court has hinted at this in a number of cases. If you're with me so far, awesome. Because this means that the phrase, the language has significance, right? Officer of the United States doesn't mean anyone in the United States. It doesn't mean all federal officers. It just means those appointed through the regular process. You're with me so far? Okay. Let's go back to our beautiful diagram, okay? And we have this sort of orange circle. And this refers to those who hold office under the United States, okay? Now, wait a minute. What's the difference between officers of the United States and office under the United States? They're both appointed, but there's one difference. The gray circle refers to appointed people in the executive or the judicial branch. The orange circle refers to people appointed in all three branches. Wait a minute, Josh. Who's appointed to Congress? The clerk of Congress? So the clerk of the House? The secretary of the Senate? There are people that each house hires on their own accord. People who transcribe the proceedings, right? The chaplain, maybe. There are different people who are appointed as officers within the House and within the Senate. Again, this is about people appointed in the executive and judicial branches. The orange circle is people appointed in the executive, judicial, and the legislative branch. And we argue that there are 4 clauses which have this language. The Incompatibility Clause. No person holding any office under the United States may serve in either House or Senate. What this means is if you are appointed, right, if you are appointed to a judgeship, or maybe you're the Secretary of State, you can't be a member of Congress. It also means that if you're appointed as a Secretary of the Senate, you also can't be a member of Congress. But there's an important implication here, and I'll be very honest about it. This is where we start losing people. There's an old understanding that this provision means that the president cannot also be a member of Congress, right? That the president cannot be a member of Congress. Under our theory, this provision would not prevent the same person, the president, from also being elected to Congress. And I think there are a lot of reasons why that would never happen. I don't think a person would run for those both offices. I don't think the Electoral College would pick someone that way. I don't think even members of a district would pick someone for both the House and the presidency. But that prohibition doesn't come from the Incompatibility Clause. Right? This provision is designed to prevent bribery. Right? It says, okay, I'll appoint you to the Supreme Court. Right? You're a member of Congress? I'll appoint you to the Supreme Court. Vote for my bill. Right? You want me the Secretary of State? Okay, you stay in Congress, you back my agenda, I'll make you Secretary of State. It was a corruption principle, right? It wasn't about people voting for different officers. This only refers to appointed positions. This also appears in the disqualification clause. This means that if a person is impeached, can you disqualify them from running for office again? No, I don't think you can. That if a person is impeached, Congress can say, you can never be appointed to anything else again. But if you want to run for office, you can. Let the people decide. Same for the Elector Incompatibility Clause. So generally a person, right, a senator cannot be a member of Electoral College. That makes sense. A person who's appointed can't be a member of the Electoral College. That makes sense, right? It says, I will appoint you the Secretary of State if you vote from the Electoral College. That's bad. But the president can actually vote for himself. That might bother some people, doesn't bother me. Every 4 years we see an incident where the president goes to the ballot box and votes for himself. We know who he's voting for. So I don't have a problem with that. Which brings us to the key provision which actually people care about, right? No one cares about these other provisions. They care about the Foreign Emoluments Clause. And it applies to those who hold profit or trust under the United States. Seth and I argue quite vigorously in a lot of different forums. We filed many briefs on this point. That an elected official like the president does not hold an office under the United States. That this provision was applying to appointed people. So if you're a diplomat, an ambassador, the Secretary of State, you can't accept foreign presence. That much we agree with altogether. But the president doesn't fall within that category.
Hey Josh, before we move on,
Yeah.
just
Yeah.
be clear about what we're accepting here. So what you're saying is that a president who is impeached can then run for president again because not disqualified.
Yes.
A president could serve in Congress.
Yes.
As a senator or a representative.
These clauses don't prohibit it, but yes.
So is there some other prohibition, or is that just it doesn't come up because
I think there are certain structural things. For example, Akil Maher writes about this, right? Let's say the vice president's being impeached.
Mm-hmm.
Who presides at the impeachment trial? The vice president. Right, if you're the vice president and you're being impeached, you preside your own trial. And you could just rule the entire thing out of order. there are a lot of things in our Constitution that don't quite add up, and the reasons why it wouldn't happen. I'll give you another one, right? In the election of 1800, there were disputes in the Electoral College. There was a huge debate. Who was responsible for counting the electoral votes? The President of the Senate. Who was the President of the Senate? Thomas Jefferson, who was the guy. And there's even some evidence that Jefferson may have interpreted the votes in perhaps not the best way, because there were some paper records, right? It wasn't always clear how different states allocated their votes. There's some evidence that maybe Jefferson didn't count the votes correctly. Maybe it's right, maybe, I don't know. There are a lot of incidents where the Constitution itself has things that we would recognize as bizarre, right? We don't think this is that problematic. Yeah, go ahead.
So just to get on the table, I mean, I don't mean to pick apart your
Please.
argument, but what we're all accepting with this interpretation is that the president, an impeached president can run for office again, that the president can be an elector, serve in the electoral college.
Yes.
And that these clauses don't prohibit a president from also simultaneously being a senator or representative, though there may be some structural principle that does.
Yeah.
Okay.
That's our position. Yeah. No, and I think Teddy hit the high notes, right? It seems weird. Like how could it be that the president can also be in Congress, right? That seems so strange. I agree. It's weird. It's never happened. No one's even tried to do it. But if we take the text seriously, there might be other things that stop it, but not these clauses. Okay. Let's move on to the next ring. The Dante's rings of hell. My next ring, which is office under the authority of the United States. And this language is only used once in the Ineligibility and Incompatibility Clause. And it says, I have double quotes there, sorry. No Senate representative shall during the time for which he was elected be appointed to any civil office under the United States, which shall be increased, or the emoluments whereof shall be increased during such time, and no person holding any office in the United States shall be a member of either house during its continuance of office, okay? So this is what most people think of as the Emoluments Clause. Let's say I'm a member of the Senate, and I vote to increase the salary of the Secretary of State. And then, gee whiz, the President appoints me as Secretary of State, right? That's a problem. So this provision was designed to prevent a member of Congress voting to either create or increase the salary of a job and then being slotted into it, okay? Now, the key point is this is not just office under the United States. Sorry, not just office under the United States, office under the authority of the United States. And these different languages, office under the authority of the United States, we argue, includes appointed positions in all three branches of government and also includes other types of positions. And these are somewhat obscure, but I'll just give you one of my favorite ones, right? If Congress issues a letter of marque and reprisal to a ship's captain, what this is, it's basically a license to be a pirate, right? You become a privateer, right? And this actually happened a lot back in the days of the Barbary pirates, right? You're now under the authority of the United States, but actually an officer of the United States or an office under the United States. I realize this is somewhat obscure, but this is a very broad prohibition. For example, Congress can't issue a letter of marque and reprisal, and that member of Congress gets that letter of marque and reprisal. These are structural provisions, okay? But this one's not too important, okay? Let me finish up the diagram. The last language we have is public trust, and this is only used once. It's in the religious test clause, which says no religious test shall ever be required as a qualification to any office of public trust under the United States. And we argue this is just about everybody, right? It's the broadest category of federal officials. It includes everything else. And we also think it would probably include the president and the elected officials as well. Okay. Now, Josh, what evidence do you have, right? Now, this is probably what Teddy's going to ask me in a minute. It's fair. We start from the premise of the text. This phrase, office under the United States, I'll get back to it, right? We have a history. Back in jolly old England, there was a phrase, office under the crown. It's used to this day in England, in Australia, and other Commonwealth countries. And the phrase, office under the crown, referred to, and we argue that the American tradition continued this. And I can give you reams of foreign sources which aren't really important right now. But we also look to practice. And this is actually what got Seth first interested in the topic. Okay? So let's talk about George Washington for a minute. Usually, We say that George Washington was our first president, and the examples he set were important, right? The examples he set sort of defined how presidents say view their constitutional role. Is it possible that George Washington flagrantly violated the Constitution? Sure, it's possible, right? We know that John Adams, for example, enforced the Sedition Act and the Alien Act, which we generally view as unconstitutional, and they did lots of things. But these were contested issues, the Sedition Act and the Alien Act. If George Washington took some action that amounted to basically foreign bribery, you'd think that people something or opposed him or did something. You think that his advisors, James Madison, Jefferson, Hamilton said, no, you can't do that. But we have evidence that Washington behaved consistent with our reading of the clause. So, for example, Washington had a plantation at Mount Vernon. He routinely did business with foreign governments. He sold tobacco and other, I'm sorry, not tobacco, I think it was the grist stuff. He sold crops, right, to foreign nations. I don't know farming. He sold crops to foreign nations. If, in fact, an emolument is any sort of business transaction, then Washington broke the law brazenly with public records. We also know that George Washington purchased land from the federal government. He purchased land in the federal government auction for money. That would technically be an emolument from the federal government, which would also be prohibited. We focus on two pieces of evidence which I have on the screen for you. President Washington received gifts from foreign government officials. This is the key to the Bastille. If you ever go to Mount Vernon, it's hanging on the wall. This was given to him by Marquis de Lafayette, who at the time was a French government official. Now we know Lafayette and Washington were BFS, right? Go watch Hamilton, the musical. But at the time, Lafayette held a government position. He was authorized to give the gift, and we think it was a gift from a foreign government. Later, Washington received this gilded frame, this beautiful, it's a full length, it's like 5 feet long, it's huge, of King Louis XVI. You even see, at the top is the fleur-de-lis, that's the crest of the French monarch. The bottom, it's hard to see, this is the Washington seal, right, with the 3 stars and 3 stripes. And this was given by the ambassador from France as a gift to bolster relations between the two nations. Again, this doesn't prove that Washington adopted our reading, but had Washington not taken our reading, he would have been openly violating the law. Okay, again, not dispositive. Washington's not alone. We also have President Jefferson. President Jefferson received a bust from a Russian diplomat of the Russian Tsar. Again, this is a gift from a foreign nation. It's very different than any sort of Trump hotel payments for sure, but it's a present without any question. And Jefferson even said, I'll make an exception to my usual policy of not accepting foreign gifts because I'm so, I have such reverence for the Russian monarch, the Russian Tsar. Jefferson also received these. What are these? Lewis and Clark, their great expedition out west. They brought back gifts from the Mandan tribe. These were foreign nations. If you ever take Indian law, the Indian tribes were more or less considered foreign nations. These gifts, he put them on display at Monticello. These were personal keepings. He did not deposit these with the government. He kept these. And if you ever visit Monticello, to this day, you'll still see these trinkets on display. Okay? But we have textual arguments. And this was actually one of our stronger pieces of evidence that created a bit of a stir a couple years ago. At one point, the Senate asked Alexander Hamilton, the secretary, for a list of every person holding any civil office or employment under the United States, except the judges. And again, Hamilton was asked for a list of people holding office employment under the United States. This is almost identical to the language in the Foreign Emoluments Clause. What did Hamilton do? He only gave a list of appointed people in the executive branch. He omitted the judges because they said no judges, right? Hamilton's reading was consistent with our theory. And look, Hamilton was a smart lawyer. It's difficult to even say that. He was a genius, right? He knew the legal tradition so well. He knew the British drafting practices. He knew how these things operated. The Senate said, give me a list of people who hold office under the United States. Hamilton gave a list of appointed people in the executive branch. He didn't list the president. He didn't list the vice president. He didn't list members of Congress, right?
Can we go back to the
Yeah.
request now?
Yeah.
So what are they asking? Are they asking for a list, or are they asking for
A statement of the salaries, fees, and emoluments. It's actually even greater.
Salaries, fees, and emoluments that go to all of these people.
Mm-hmm.
Was there any question how much money the president made?
Well, that was set by statute, yes.
And was there any question how much money judges made?
That was set by statute.
So everybody knew how much money the
Yeah,
judges
it's a common refrain, but see, there were other lists in which Congress did ask for the salaries of the president. Yeah, no, but I mean, see, Teddy is exactly on point, right? There were a lot of lists. Most people haven't even found. We have lists. We have lists galore. But there were other lists in which they did include the salary of the president, and there were different requests and different ways they phrased them. Okay, so we have this list, and he starts off with the Secretary of State, the Treasury Department, the Secretary of Treasury, the Department of War, all these appointed officials. Okay, this created a bit of a stir about 2 years ago. That lonely scholar was my client, Seth Barrett-Tillman. Some professors at a couple of law schools, you've probably heard of, big law schools, accused me, Josh, of lying to the court. As I say, come at me, bro. Right?
Wasn't me.
What? No, it wasn't Teddy. Most people wisely stood out, but a couple professors at Fordham and Georgetown and Stanford, big colleges, they accused me of lying to the court. And they said, no. Blackman's misleading you, right? The Hamilton document he gave you is not the real Hamilton document. We know better. Ready for this? They say, we went to the National Archives and we found the original document, which lists the president's salary. You beat my punchline by a minute. No, but they had the same intuition Teddy did. They said, we went to the archives and the actual Hamilton document, signed by Hamilton, lists the president. Were we worried? No, we knew about it. Seth heard about this years ago. Okay, so this is a document that we had. It's hard to read, but see this little squiggle? That says Alexander Hamilton. I mean, it's hard to make out, but you can read it, right? This was a document we had, drafted in the 1790s, right? It says Alexander Hamilton, Treasury Department, February 26, 1793, okay? This was a document we had that did not list the president's salary. Okay. This was a document they found, drafted in the 1830s. See that little there? Alexander Hamilton, Secretary of the Treasury, President of the United States. They said, we found this document. Now, you guys aren't historians, but you can pretend to be for a minute, right? This was Hamilton's signature. Look like the signature? Would Hamilton squiggle his name, this little thing? Do you know what this document was? It was a copy. It was a Xerox, basically, made by hand, right? 3 decades later, where the Senate and Congress were merging various pieces of information to create a consolidated list of the salaries of all officers in the government. They modified it. They changed it. In fact, they actually destroyed books. It breaks my heart. They actually cut pieces out of official records and glued them around and made new entries. Like, that breaks my heart. I don't know about you. But we knew about this. And we actually flagged this in our brief. And the professors said that we misled the court. Well, that is not the real Alexander Hamilton. They apologized. They apologized. They apologized. In fact, they did the right thing. They withdrew their pleading. You'll never see this in court. In a footnote, they filed a letter with the court withdrawing their. I know you can do that, but you draw a footnote. They never quite said we were right, but they withdrew their attack on us. So I'll give them credit. I think their scholarly approach initially was wrong. Had they come to us and said, Josh, we have this other document, can you explain it to me? I would have told them right away. But they decided to put in a court pleading. And, you're all going to be taking the bar in a year or two. If another lawyer says that you're lying to the court, you take that seriously, right? You have one reputation, you only get one. You can't burn that. I think Professor Ray will second this. You do not lie to a court, right? If there's any ambiguity on a source, you tell the court, Your Honor, here's the document. We think this is the best reading, but there might be this other document, whatever, which we did. Anyway. And yeah, here's a letter. They respectfully withdrew footnote 82. I didn't know you could do that, but apparently you can withdraw a footnote, okay? Nunc pro, oh, I love that one, yeah. It was as if it was never filed, but it was, right? Okay, but I think they did the right thing. So why am I going through all this history, right? We will admit candidly and honestly that these questions are difficult, right? if we want to take text seriously, you have to look at the drafting practices, you have to look at Hamilton, you have to look at Justice Story, you have to look at the practices of Washington and Jefferson and other presidents. You can't just assume on an intuition that this clause applies to everyone, right? And I'll put the language back up for a minute. You can't just assume that, of course, people in the United States means all federal officers. You can't assume that. And again, I don't have rock-solid evidence, right? I wish I had a statement from Alexander Hamilton saying, you know what, President Washington, you don't hold office under the United States, so take that gift from Lafayette. Oh, I'd love that. But in history, you seldom have these sorts of smoking guns. So you have to draw inferences from various sources. And we think our inferences are well supported. We think the other side, which I didn't get to, maybe I'll mention after Teddy goes up, if you take the position that this language can mean any federal officer, you have redundancies. You render language of the Constitution surplus. It repeats itself as necessary. You have these various puzzles that don't make sense. Our position, which has weird things about the president being in Congress, I get it, doesn't have those sorts of problems. So ultimately, I'll stop here and I'll give it over to Professor Rave. I don't think the Supreme Court is going to adopt our theory. I mean, if they do, that'd be awesome. Maybe we'll get 1 or 2 votes in a concurrence by Justice Gorsuch or Thomas. I'd be happy with that. But what I think the court will have to do is leave this question open. They'll say, we don't have to decide if the president holds office because there's no standing, for example, or the case is a political question or something else, right? But if they say, as the judge in Maryland said, that this clause applies to the president, they have to make the argument, and they're not going to do it. And I will take that much as a moral victory. Thank you so much, Professor Rave. All to you.
So thank you. This is, I think, tremendously informative and a really good way to walk through what a textual, I believe what they call this is an intra-textual
Exactly.
Kind of argument for how you interpret the Constitution. You have to look at what all the words are doing in their context and how they relate to each other. And I think this is a really elegant argument, and I know better than to accuse Professor Blackman of lying to court. His co-author on this, Professor Tillman, has been at this for, I came across this in 2012.
Did you? Wow.
And it was not new then. So this is certainly not like an example of anti-Trump motivated reasoning. Like this is an analysis that was done outside of any context. It's back when nobody knew what the Emoluments Clause was, before Trump succeeded in making the boring parts of the Constitution great again.
I'm going to steal that.
And I think that Professor Blackman is very candid in admitting that this is a hard question, right? He doesn't have slam dunk evidence for his view. He has an elegant intratextual argument and some historical pieces that support it. I think the practice of George Washington is a very strong piece of evidence that definitely, if you take a contrary interpretation, you have to deal with. There are some other things that cut the other way, though. One of them, when he was going through the kinds of things that you have to accept about what a president can do if you accept his duty of officer of the United States. The kinds of the president can serve in Congress and can be in the Electoral College. And maybe we have structural principles that deal with that, right? But then you have to make a structural argument when there's perhaps a more straightforward textual argument. As far as the understanding at the time of the framing, I don't think it's quite that open and shut. And again, I don't have any slam dunk evidence going the other way. But at least some of the framers thought that the clause applied to the president. So Edmund Randolph, who was at the Constitutional Convention, said at the ratifying convention of, I believe, Virginia.
That's right. That,
of course, the clause applies to the president. And if the president were to accept foreign emoluments, that would be grounds for impeachment. So I mean, I think this is one of those issues that has evidence going both ways. I do think that if the Supreme Court were to reach this question in the Maryland case or some other case, they would have an easier time ducking it than having to dismiss on standing. they could just point out that the president himself does not argue that the clause doesn't apply to him, and the executive.
Not exactly.
Not exactly.
That's our. So we eventually Seth and I will write a book on this, but we've been we've been pushing this issue. DOJ actually submitted a letter saying that we only assume it applies to the president.
Okay, so
and that's actually they've not actually waived this issue, which we're very careful to point out.
And the current DOJ is very happy to reverse position on constitutional issues on the drop of a dime.
They are.
So maybe they will reassert that position, but it has been the long-standing interpretation of the executive branch that the Foreign Emoluments Clause does apply to the president. There are many memoranda from the Office of Legal Counsel taking that position. I think most recently, OLC wrote a memo explaining why it was okay for Obama to accept the Nobel Peace Prize, because the Nobel Committee is not a foreign prince or state or something like that. And like I said, the Washington evidence is something that we have to take very seriously. But it's not consistent practice since Washington that presidents have felt free to accept gifts or other payments from foreign governments without Congress's consent. I'm gonna forget all of the presidents, but at least Jackson and a handful of others went to Congress to ask for consent.
They surrendered gifts. They didn't actually ask for consent. They said, "I can't accept this," so they give it to the government. So
I thought didn't Jackson go for something from Bolivar?
He didn't ask for consent to keep it.
Oh, okay.
Which is actually an important point.
Congress said no.
No. It's one house said it. It's actually complicated. The history. I don't interrupt you.
No.
The history.
More about this than I do.
Yeah, no. The history is actually complicated, right? We don't have any record of any president actually asking to keep a foreign gift, right? We don't have that evidence. In several cases, it was Van Buren, Tyler, and Jackson. I might be in them out of order. They basically said, "I got these foreign gifts. I can't accept them. Congress, you take them." So it's given basically the State Department. Lincoln as well has two examples during the Civil War where he received foreign gifts. And he basically gave them to the State Department. They keep them the Hall of Curiosities, this awesome sounding room with all these like foreign, like elephant tusks, like very like intricate and very esoteric gifts. But we don't have a president actually asking for consent.
Okay.
That's history. But you're mostly right. Yeah.
So we have, it's not open and shut here. I guess, and I don't have I haven't looked at the original sources like Professor Blackman and Professor Tillman have. So it's hard for me to really weigh in on the historical arguments here. I guess if you just sort of zoom out a little bit and think about what these clauses are doing in the Constitution to begin with, then maybe you would push back on some of these limiting interpretations a little bit. If, as I think most people think, these are anti-corruption clauses, right? They're supposed to be in there to kind of prevent foreign governments from buying off people in the U.S. government. It seems a little odd to leave out the biggest target of potential foreign influence. And that's not something that the framers were like unaware of or unconcerned about. I mean, you could think of the entire American Revolution as just a proxy war between the British and the French. And in the post-Washington era, I mean, the Federalists were in league with Britain, and the Democratic Republicans were in league with France. So foreign influence for a young country that had formerly been a colony was a big concern. And so, if you, I think it's a totally plausible reading to think that this clause does apply to the president. It's interesting that we haven't really talked about kind of the issue that everyone else is fighting about. Do fair market value transactions count as emoluments? And I guess I'm just sort of curious about your position on that. I mean, you suggested before that some of the things Washington did would have violated the Emoluments Clause if it applied to him. So.
Sure. Well, let me make 2 points, and I'll get to the point about emoluments. Corruption is a good argument, right? I I don't have a silver bullet in response to Professor Rave's argument that they want to root out corruption, but I'll give two smaller arguments that might be relevant. The electoral process was designed to put in people of character, and they can be impeached, perhaps, and removed. We think there's a different standard of those who have to go through the electoral process and those who are appointed by the Senate. So I think there's a greater risk of corruption by appointing people not elected. One other point on the executive, why would they exclude the president? This is important. President Madison received a dueling pistols from a South American leader. And he said, I want you to accept these pistols as a sign of respect between our two nations, basically what's modern day Argentina, the Rio de la Plata, right? Had Madison accepted those gifts, he would have been effectively recognizing that nation, that breakaway republic, meaning it's not Spain. That was a significant decision. We had a conflict where in Congress, I think it was I think it was Clay, saying, we want to recognize these breakaway republics, and Madison's like, no, I don't. I think there's actually a good reason why the president should be able to decide which gifts he should and should not give to Congress, because they actually affect recognition. The Zivotofsky case, the passport case, which you studied. So I think I actually have a good argument for the president, maybe not for other ones, but I think a good argument. Now, the emolument issue, again, this is a word which I didn't even mention in my talk much. We argue it does not concern fair market transactions. It refers to benefits that arise from an office. And indeed, the text of the Constitution links emoluments from those who hold office. Again, I actually think this argument has merit on both sides. I do. Depending what sort of founding era sources you can see, there are some sources that describe it as a fair market transaction, or anything of value, and otherwise. Here, I'll give a little bit more of a structural argument. If we take the position that an emolument means anything of value, right? A lot of presidents have violated this clause. For example, President Obama had a book. The book was sold in Chinese libraries. That generated royalties. That's an emolument, right? De minimis value for sure, but it's an emolument. Most presidents have
state-owned libraries.
Yeah. I mean, the entire government's a state-owned, which I use China, right? That's why I use China. Yeah. I mean, you have presidents who have investments in treasury bills, right, which generates interest from the United States. You have presidents who have holdings where they might have companies that might do business overseas, which might derive profits from foreign governments. My favorite example, Senator Blumenthal, who I don't think is bound by the clause, but if he is, he's breaking the clause. Right? His family basically owns the trust that owns the Empire State Building. There are lots of foreign tenants to the Empire State Building. So if we actually go down the road of the anything of value argument, that renders a lot of presidents violating the law. And we have George Washington. The district judge actually said from the bench, so what if George Washington is violating the law? No one was there to stop him. Okay, I mean, that's an argument, but I think it's an argument that's not going to prevail, right? He said, okay, maybe Obama broke the clause, but no one was there to challenge him. Okay, I don't know. All right, want to do Q&A? You want to, anything else?
Yeah, let's do Q&A.
Okay, so please, questions from the students. Is that a hand there? Come on, yeah.
I have one. This is admittedly less eloquent because my knowledge of history is significantly less than two of you. Professor Blackman, when you mentioned that when George Washington would have broken the law had he taken the contrary view on the Emoluments Clause, you said that having the Constitution just ratified and everyone was revved up to defend it. When you said that, my first thought was we learned in 7th grade U.S. history that the only reason George Washington is the king of the United States is because he didn't have enough ambition to accept the will of the people who all wanted him to be king. So I guess my argument, with my limited knowledge of history, is at the time, did people really care about defending the Constitution if they more or less wanted the president to be king?
Oh, I see your point. So one point general, one specific. Washington had opponents, right? Political parties started bubbling up fairly short after the Republic was founded. And there were people who were basically anti-administrativists, whatever the word is, but they were against the administration. So there were people who were out to get Washington. And I think there were debates about the president's power, right? One of the biggest debates was called the neutrality power, right? Did the president the power to declare neutrality with France and other nations? And there was a vigorous debate between Hamilton and Jefferson about whether this was too much of an imperial power. So at least in that debate, there was a discussion, was the president going too far? But these gifts, which were in full display, occasioned zero protest from anyone. Because I don't think they were I don't think the tobacco or the crops were emoluments. I don't think those payments were even considered. And I don't think the president thought he was bound by this provision. We have debates later about whether appointed people, right, ambassadors and diplomats could accept foreign gifts, but not about the president. By the time you get to Jackson, though, I agree with Teddy. The president said stuff that seemed different. For example, President Lincoln wrote in a letter, under our Constitution, I cannot accept foreign gifts. Well, it doesn't actually say that, though, right? It says you can accept it with consent of Congress. And I actually think those sources suggest Lincoln didn't want these stupid gifts from foreign. He was fighting a civil war. What did he want with these elephant tusks, right? So I think he would often say these things to sort of just placate the diplomats, saying, don't worry about it. But like they said, I can't accept this gift, period, full stop. And that's not exactly what the clause says. But I agree, there are different practices, and I think we have to contend with that.
Other questions?
Going once? Yeah, right there.
So in the language there, though, without the consent of Congress,
Yeah.
Is there any argument to be made that that language being there places, in context of the larger constitutional structure, is a huge check on the other branches, the consent of Congress?
Yeah.
It's found in the other two articles. My question is, without the consent of Congress, without having that check, what's its point of being here if not to place a check on the other two branches, specifically the president?
Okay, let me. So under our theory, members of Congress are not subject to this clause, right? But let's say I'm wrong, right? Let's say that members of Congress are subject to the clause. In that case, you would have the House voting on whether one of its own members can accept a foreign emolument.
I don't think that was the question.
No, I know that wasn't the question,
Oh, okay.
but I'm going to get there in a minute, right? I'm going to get there in a minute,
All right.
I promise. Right, so under that theory, then the House would vote on the consent of its own members. There's a general principle that you can't have, for example, the Senate voting on the House's internal business, right? Each House is a judge of its own proceedings. So there's a problem if we say that it's about checking, right? Because each House usually takes care of its own business. So if we're right that one House can't check another, then at a minimum, members of Congress are exempted. And if the members of Congress are exempted, it's not such a crazy thing to think that the president's also exempted because you have an impeachment clause for bribery, right? This is the argument DOJ will never say in court, which I will. Most of the time, if a foreign leader, if a president is accepting gifts from abroad, there's a quid and there's probably a quo, and there's probably a quo, quid pro quo, right? There's probably a bribe. And I think that there's a mechanism, right? Not just saying you can't accept it, but remove you from office for that kind of corruption. So I think there are other checks on that executive power.
So before we take one last question, I kind of want to respond to that because I don't think I disagree with you that impeachment is a big check here. But we end up putting, I think, a lot of pressure on the impeachment process. If we start saying that everything like this is a political question that should be solved by impeachment. So, one way you could read the Washington precedent is that Washington interpreted the Constitution and determined that the best reading was that he was exempt from the Emoluments Clause, because that's what everyone kind of thought at the time. It just doesn't apply. Another would be he didn't want to be rude to the French, who were important allies, and Congress didn't impeach him because Washington was extraordinarily popular. And so if everything is going to have to rise to the level of impeachment before we can start to get traction on these questions, I mean, it seems like we're putting an awful lot of pressure on that process.
Very good. All right, let's do one last question. I saw a hand somewhere. Yeah, right there.
This is on a slightly different path, but I'm just wondering if you have any insight on this. So I guess I noticed that this clause is in the section powers forbidden to Congress, and this particular provision within the clause sort of seems out of place. It's not really a prohibition to Congress except for the first part. Is there anything in
Yeah.
line of argument as to what it's doing there that helps you or not?
Yeah, so there are three emoluments clauses, right? There are actually three, well, three depending on your count, right? There's one congressional emolument clause, which says that Congress can't create an office and they get appointed to that office later, right? Or Congress can't increase the salary of an office and be appointed to that. This is a clause which concerns people who are appointed, we argue, right? If you're an executive or judicial branch employee, right? And then there's a clause for the president himself, that he can't accept other forms of compensation from the states or the federal government. So we argue structurally there's one for Congress, there's one for appointed officials, and there's one for the president. And that lines up very well with our theory.
All right, well, guys, we're out of
That's it.
time. Please join
Thanks, Debbie. That's good.